Tom, I'm sorry, hang on 1 second, it's still just. Okay, will you start that again, please?
We'll convene the hearing in application 4C0449-8, the H at Malletts Bay, Colchester. Today's Thursday, July 23, 2026. We are the District 4 Environmental Commission meeting to conduct a merits hearing on application 4C0449-8 filed by the applicant, Hazelett Strip Casting Corporation. The application is seeking authorization for a project generally described as a redevelopment of the Hazelett waterfront parcels entitled the H at Malletts Bay. The project proposes an inn with a series of 5 cottages and a total of 20 rooms, in addition to a main building with a 48-seat restaurant at the main level, an event space and spa facilities. Additionally, the project proposes a new bathhouse to provide toilet and shower facilities for beach users. New parking is proposed across the street at 135 West Lakeshore Drive. The project is located at 135, 166, and 180 West Lakeshore Drive in Colchester, Vermont.
You gotta be first.
I am, yep.
Pursuant to Act 250, Rule 16, we held a pre-hearing conference, the PHC, on May 13 for the application for the purposes of identifying contested facts and legal issues, discussing party status, and determining a hearing schedule. The commissioners, the applicant, and residents of the project area conducted a site visit prior to the pre-hearing conference. The site visit included crossing West Lakeshore Drive and walking down from the street to the Lake Champlain shoreline area of the project tract, stopping along the way at places to observe conditions pointed out by those on the site visit, and then walking back to the starting place. The pre-hearing conference was conducted pursuant to Act 250, Rule 16, with myself, Chair Thomas Little, presiding. Pursuant to Act 250, Rule 13B, the Commission recessed the pre-hearing conference pending submittal of additional information by the parties as determined in the pre-hearing conference recess order that was issued on June 16. Following that recess order and the submittal of additional information, the Commission issued a pre-hearing conference report and order noticing this merits hearing, making preliminary party status determinations, and narrowing the criteria considered at the merits hearing to the contested criteria, which the applicants and other parties will provide testimony on or submit documentary evidence about. That order was issued on July 2. The Commission received an objection to the determinations made in that order by Save Malletts Bay L3C on July 13, and the Commission denied the motions in a memorandum of decision issued on July 21. My name is Tom Little. I'm the chair of the District 4 Commission. I'm joined by fellow Commission members, Vice Chair Parker Reilly on my left and Scott Baldwin on my right. Caitlin Hayes is our District 4 coordinator assisting with the application. She is supported by Stephanie Monahan, our other District 4 coordinator. Now I have a fair amount of items to cover as we prepare to start the testimony, some housekeeping items, a discussion, the explanation of the Vermont open meeting law, and an overview of how we're going to proceed through the hearing. So bear with me on that. So Vermont's open meeting law applies to these proceedings, and in accordance with Title I of the Vermont statutes annotated Section 312, I confirm that we have taken the following steps. We are providing public access to the meeting by online video conference with additional access offered through telephone. We are using the Microsoft Teams platform for this hybrid meeting. All members of the commission have the ability to communicate during this meeting because we are here in person, and the public has access to listen and, if desired, participate in the meeting by attending in person, downloading the Microsoft Teams application, or by calling into the toll-free number provided in the notice of this hearing. And in addition, we have provided public notice of instructions for accessing the meeting. We previously gave notice to the public of the necessary information for accessing the hearing, including how to do so using a telephone or Microsoft Teams. That was explained in the meeting notice. The meeting notice, including those instructions, has also been provided in the meeting notice on the Act 250 database online. Under the open meeting law, by participating, you are consenting to being audio and visually recorded, and for that recording to be published on the Land Use Review Board's YouTube channel. Please be aware that the microphone that is used to record the hearing is extremely sensitive. It will pick up and record whispers and side conversations. Anything that is recorded will be published as part of the public record. Any written information or exhibits provided to the Commission or Act 250 staff about official state business are considered public records and will become part of the permanent record to be published in the Land Use Review Board's online database. If you would like to speak during the hearing, please raise your hand and wait to be recognized by me. Everyone will have a chance to present their evidence and respond to the information presented. There is no need to interrupt or talk over the individual who is currently speaking. And when you speak, please state your name for the record. Now, are there any persons who are participating remotely who are going to be testifying today for council?
Well, so Tom Berry
Is here.
is here.
Jim Pease
Jim
is coming
Pease
this afternoon.
is coming this afternoon, so he'll be here in person. I don't think we have anyone remote only.
Is John Groveman going to be?
John's gonna be signing in, yes.
He's here now.
Okay, yeah, but he's not gonna be here in person unless, well, yeah, he'll be here remotely, but not.
Well, let me
Did you hear from Diane Snelling?
She's supposed to be here.
let me go through the next piece of the protocol. The chat function has been disabled for the Teams meeting. If you are participating online via Teams and start having technical issues at any point, you can call into the meeting on your telephone by following those instructions in the written hearing notice. If you are participating online via Teams and would like to speak during the hearing, please use the raise hand feature, which is located in the toolbar in the top center of your screen. If you are participating by phone, press *5 to raise your hand and then *6 to unmute your microphone. And when done speaking, please press *6 to mute your microphone. And lastly, for this part, do not log into the Microsoft Teams meeting on your computer or other device, and also participate on your phone at the same time, because that will cause very distracting audio feedback that can disrupt the hearing. So let's start by taking a roll call of attendance of everyone participating in the meeting. Do we have both sign-in sheets?
I do.
Okay.
Is everyone here signed in on this sheet? Who's in the room? Great.
So, Caitlin, why don't you go through the list, and as she calls your name, raise your hand to identify yourself.
Okay. Bryce Simon, Chris Roy, Marilyn Sowells, Jen Mojo, Deborah Price, Jerry Allen, Jess Gassett, Scott Hosted, Jeremy Owens, Jen Connolly, Ben Avery, Jeanette Berry, Jeannie Welch, Nancy Cloutier, Tom Berry, Lori Bard, Brian Costello, and Chris Cloud.
How about online?
Online, we have Pam Loringer. We have a few folks from VNRC, John Groveman, and forgive me, I'm going to mispronounce her name, Murjami Yinin. We have Bryce and Chris are online, Charles Pete, and Mary Lee Ritter, and Adrian Katz are also online.
Okay. Participants are reminded that everyone who has been preliminarily granted or requested party status and any other person who would like to continue to receive documents associated with this application proceeding must give us an email address or a mailing address legibly. If you haven't already done so, please email the Act 250 District Office, provide your full name and contact information. You can find an email address for the district office in the notice for the meeting. The commissioners have reviewed, as we did before and at the time of the pre-hearing conference, have reviewed all of the materials submitted for the application, in part with an eye towards identifying any conflicts of interest that one of us might have. We are not aware of any conflicts of interest that need to be disclosed at this time. Ex parte communications. Outside of today's proceedings, I remind everyone that all communications, whether by letter, email, phone, or in person, must flow through the district coordinator, Caitlin Hayes, and not through other parties or the commission members. The purpose of the hearing, always helpful sometimes to state the obvious. We are charged with collecting evidence as to whether this project meets the requirements of Act 250. And based upon that evidence, to decide to issue or deny the permit applied for or to issue it with conditions. Overview of the hearing process. The applicant will present the project in brief. In other words, an overview of what is proposed, probably with reference to the site plan. Then we are going to consider any new party status requests or requests for participation rights and determine under which criteria they may be preliminarily admitted. At the time of the pre-hearing conference, we noted for the record that there were some adjoining neighbors, property owners, who, for one reason or another, did not receive the mailed notice of the proceeding. And there was also a question about the timing of the poster on this site. So with the support of the applicant, we are still able to consider new requests for party status. Do we know whether we have anyone who is going to be requesting party status for the first time today?
Not from our group.
Okay. The applicant will present evidence on all of the contested criteria. Those are, for those of you keeping track, there's a lot of them. Criterion 1, 1B, 1C, 1D, 1G, 1F, 4, 5, 7, 8, 9A, 9H, 9J, 9K, 9L, and 10. What we mean by that is that the applicant is going to go through its pre-filed testimony on the criteria, all of the criteria itself, as opposed to going through doing one of them and having other people ask questions, and then the applicant presents some more evidence. We're going to have the applicant go all the way through from 1 to 10. We've found in the past that with pre-filed testimony, that is a fair and effective and efficient way of doing it. For example, for criterion 1, the applicant will introduce its pre-filed testimony on that criterion. The witness will be asked to confirm the completeness, after being sworn, confirm the completeness and truthfulness of the pre-filed testimony. If there are additional applicant witnesses with their own pre-filed testimony on criterion 1, they will do likewise. The applicant will then do the same for each of the other contested criteria. When the applicant has completed its pre-filed testimony presentation for all of the contested criterion, the statutory parties, which includes the town and the state, who wish to cross-examine the applicant's criterion 1 witnesses will do so. And then the other interested parties through their attorney will proceed with cross-examination of the criterion 1 witnesses from the applicant. I'm just going to make sure then the applicant through its attorney may ask redirect questions of each of its witnesses for criterion 1. Following that, the other parties may ask cross-examination questions focused only on what the witness said in their redirect testimony. And that will go all the way through on that criteria, and we'll go through all the criteria. The statutory parties first, and then the other interested parties. Then the statutory parties, A&R and others, will present their own direct testimony on the criteria they are interested in, following cross-examination and possibly redirect testimony and recross testimony. And then the other interested parties will present their pre-filed testimony in the same sequence and manner as the applicant did, as just described. The applicant and the statutory parties will then have the opportunity to cross-examine those witnesses, and then there will be redirect and recross questioning. We can encourage the applicant and the other parties to be focused and concise in their testimony and questioning, and to try to avoid duplicative testimony and questioning. We have read all of the filings and the pre-filed testimony and exhibits. We are sworn to provide each party with a fair opportunity to be heard, and we will do so. Now, here's the big question of the day. Does anyone have any questions about how we will be proceeding? Yes, sir. Mr. Roy?
Yes. We have obviously witnesses who speak to multiple criteria. And just as a matter of logistics, do you want to do it? We present, the witness comes up, affirms their testimony, and then makes themselves available to answer questions with respect to all of the criteria that particular witness speaks to? Or do you want us to go back and forth?
No, I think what we intend is for you, with that witness, to have that witness, under oath, confirm the accurateness and truthfulness of all of their pre-filed testimony. And then, I think, move on to the next witness for other of the contested criteria and they can do multiple criteria until we get all the way through all of your pre-file. I don't think what I said actually addressed if you have any witnesses for whom there is no pre-filed testimony. Okay, so thanks for that.
Can I just ask, so just to be clear, we'll be cross-examining each witness on all the criteria on which they've testified. We're not going to break up the cross by criteria.
I think that makes sense. We'll see.
Yeah, that makes sense to me.
If it gets
confusing otherwise.
Confusing, we will reboot. So now I'm going to ask anyone, either in person here today or online, who thinks that they might address the commission and give testimony during this hearing to swear or affirm that you will tell the truth. Accordingly, anyone who expects to address us, please raise your right hand. Do you solemnly swear or affirm that the testimony or evidence that you will provide relative to the consideration of this application shall be truthful, accurate, and complete under the pains and penalties of perjury? If so, answer, I do.
I
do.
Is there anyone who wants to answer, I don't? Okay. I have to do that because of the online stuff. So now, Caitlin, you have anything?
The only thing I had a note of is actually for A&R. I just noticed in the most recent comment that you had also, A&R also wanted to speak to criterion 1E, which was not in the original comment letter. I mean, we can incorporate that now. I just want to.
I included Jen Mojo for the record. I included it with the agency. I did include 1E in our most recent submittal, as there are streams located on the parcel, and we had asked for additional information about activities occurring on that 133 property.
Okay, could you do us a favor and come into a closer chair?
Yeah.
For some of the hearing challenged members of the panel and others?
And if you want to, you're welcome to put a chair if you'd like.
And maybe just repeat Caitlin, could you repeat your comment and then your response?
Yes, my question was just that in A&R's most recent submittal for their expert testimony in response to the pre-hearing conference report order was submitting comments and a request for additional information under criterion 1E for streams, which we did not have on our list previously.
Okay. Okay, and
Oh, sorry, that's yours.
yes,
Is there anything, several of us are
could
struggling.
you please identify yourself?
Sorry, Jean Well. Several of us are struggling to hear the proceedings. Is there any way the volume can be increased? I noticed Jerry didn't hear. He was supposed to put his right hand up. Sorry. And I'm in the same boat as is.
Well, I can see two things. We can all get closer together and we can ask everyone to speak up. Use your outdoor voice, your school teacher voice or your camp counselor voice, as the case may be. Thank you. So the applicant will now give a brief overview of the project, and since I don't believe we have anyone requesting new priority status, we don't need to do that. And
could I just say regarding 1E, to the extent that we don't have party status on 1E and it becomes a question or an issue, we'd like to be able to participate on that criteria.
okay. So the applicant, you have the floor.
Thank you. Benjamin Avery for Hazelett Strip Casting Corporation. And there's a detailed overview of the project filed as part of the pre-filed testimony. But to give a very brief overview, the proposed project is a 20-room inn located at 166 and 180 West Lakeshore Drive. It is comprised of 5 cottages and 1 main building, the main building containing a 40-seat restaurant and related event and meeting space on the 2nd and 3rd level. In addition to that, we are proposing a small bathhouse for guests to be able to use that is a little further down the slope towards the beach, and a support building on the opposite side of the road, primarily for storage, restrooms for the existing mooring field, and that also is located between the street and the proposed parking for the project. That parking will be connected to the main building via a signalized crossing across West Lakeshore Drive. And that's pretty much the overview of the project.
I thought I heard you say the restaurant was a 40-seat, and I have it in my notes as 48-seat.
We did, to address that, as I know it came up in some of the other testimony. There are obviously hundreds of pages of documents to do with a project this size. There was an earlier iteration in the town process that was 48 seats. It was reduced to 40 in the final plat application. 40 is what approved, and we'll stipulate to that 40 number going forward. And apologies to the commission for any stray 48 reference.
Okay. Then I think we are ready to proceed with the testimony on the contested criteria, starting with the applicant and its first witness. So.
Sure, and as Mr. Avery just indicated, the first pre-filed testimony we'll offer will be his, which provides a more detailed overview with respect to the project. It's not directed towards specific criteria. It's intended more, and it's an exhibit 110. Do you want us to ask the witness to affirm, or do you folks want to ask?
Yes.
Sorry.
Do you wish to ask the witness to affirm the pre-filed?
No, I think that's your role.
Okay.
Counselor. And we're going to put up a site plan on the screen just to help everyone focus on what we're talking about.
So, Mr. Avery, you've submitted pre-filed testimony marked as Exhibit 110, correct?
Correct.
Can you affirm the truthfulness and accuracy of that submission?
I can.
We submit Exhibit 110, which is Mr. Avery's overview testimony with respect to the project, and offer him up for any questions.
And which criteria does that cover?
The specific criteria are covered by the four expert witnesses that follow. This was intended to provide more of the sort of the factual background and context for the project, which then in turn supports the eventual technical testimony with respect to satisfaction of the criteria.
And I think my co-commissioners will correct me if I'm wrong. I think that our process today was going to be to hear from each of the applicant's witnesses and cover all of the contested criteria before going back and opening up those witnesses and their testimony to cross-examination.
Okay.
So you can proceed with your next witness.
Excellent.
And it will be helpful, just for the record, I know it's in the pre-file to tell us which criteria are being covered.
Yes, the next witness would be Jennifer Conley, who will testify with respect to criterion 5. Her testimony is Exhibit 111. And Ms. Conley, can you affirm the truthfulness and accuracy of your pre-filed testimony, Exhibit 111?
I can.
The next witness.
Okay, could you do that again with a little more?
I'm sorry, I can.
Yeah, thank you.
Sorry.
The next witness is Jeremy Owens, whose pre-filed testimony is Exhibit 112. His testimony addresses criterion 1F, 5, and 8. Mr. Owens, can you affirm the truthfulness and accuracy of your pre-filed testimony?
I do have, this is Jeremy Owens, I do have one correction to my testimony.
Yes, if you could identify that, please.
On page 5, at the very bottom, there's a green box around some text, and that text needs to be revised. Would you like me to read the new sentence?
Yeah, it's brief. If you could make that correction on the record now, just so it's clear.
So the sentence should read, therefore the project's exterior lighting design will not have an undue adverse effect on pedestrian safety as it relates to traffic and criterion 5.
And the pre-filed testimony that was submitted, Exhibit 112, inadvertently referred to criterion 8 as opposed to criterion 5. We just wanted to clarify that. With that correction, Mr. Owens, can you affirm the truthfulness and accuracy of your pre-filed testimony, Exhibit 112?
I do.
The next witness is Exhibit 113, which is Scott Homestead, who is testifying with respect to a number of criteria. Criteria 1, 1B, 1C, 1D, 1F, 1G, 4, 6, 7, 9A, 9H, 9J, 9K, 9L, and 10. Mr. Homestead, can you affirm the truthfulness and accuracy of your pre-filed testimony, Exhibit 113?
I can, and I would add, I would probably, since it was brought up earlier, I would probably respond to questions regarding 1E, which was not in this original testimony, but I could respond to that.
Thank you. The last pre-filed testimony that has been submitted is Exhibit 114, which is Jessica Gasek, and her pre-filed testimony is directed toward criteria 8 and 9F. Ms. Gasek, can you affirm the truthfulness and accuracy of your pre-filed testimony, Exhibit 114?
I have one small correction with regard to that 48-seat restaurant. I referenced
Could you
48.
speak up a little bit more, please?
One correction, I noted 48-seat restaurant in my project description. It should read 40, has been described.
With that correction, can you affirm the truthfulness and accuracy of Exhibit 114, your pre-filed testimony?
Yeah.
And with that, we have submitted the pre-filed testimony of the applicant's witnesses with respect to all of the criteria identified in the pre-hearing conference recess order as being contested, as well as the additional criterion referenced by the Agency of Natural Resources.
One clarifying question from the commission. We had stated that, and I think published in the notice and hearing of the order for this meeting, that the list of the contested criteria which did not include number 6, and in Ms. Grasek's testimony, Mr. Roy, you said she was covering number 6.
Yeah, 6 and 7 as a combined, so
Okay.
It's directed at 7.
Okay.
And could we just get one clarification? So to the extent that the project application references a 48-seat restaurant, are we considering the application amended?
I think we will. We probably will cover that in the recess order.
Yeah, and I think the application materials reference 40. It's that legacy 48 they'd be knocking around in some of the ancillary documents.
Page 4, I'm looking at the application. Page 4 of the application does say 48-seat restaurant. And again, I think it makes sense to have it be considered amended.
Yeah, we will stipulate to 40 and we'll abide by anything that the court orders in a recess order with respect to confirming that fact.
So I think that brings us to the statutory parties from the town or the state who may have questions for the witnesses we just heard from. So, Mojo, do you have any questions?
Jen Mojo, Agency of Natural Resources. I don't have any questions at this moment. Our comments, we had reached out to the applicant requesting additional information. We did receive a response late Tuesday, and with staff being in the field yesterday, I don't have any updates with regards to their analysis of the project. So we have received additional information under all the criteria which we requested, but I imagine that there will be additional discussions with the applicant following the hearing.
Can I just ask, is that additional information available to us? Yeah.
I'm happy to submit the email I received to the record, for the record, if that.
Yeah, I think everyone needs, the commission would
Okay.
like to see it too.
Yeah.
And that just highlights a procedural issue that I just think is important to put on the record, that, you know, all of our testimony is based on the information that we had available at the time. And so to the extent that at that time there was information requested by the agency that had not been received, a lot of what, you know, one of our major concerns today was that that had not been responded to. So however that response came in may change all of our testimony. So I just wanted to be clear that from our perspective, we may have to do this whole thing again with different information.
And the order we issued a couple of days ago, I think, it contemplates that possibility. So, I guess you have the floor now if you have questions or for any of the witnesses for the applicant who just testified.
We do have, Chris Clow is also here from V-Trans, if you would like
sorry.
to.
Oh,
Chris, if you are going to talk, will you come?
oh, it's okay. I can yell at everybody really great.
Good outdoor voice.
Exactly. Chris Clow, Agency of Transportation. No, I have no questions at this point.
Thank you. Were you a summer camp counselor?
I've done drama in high school.
Okay.
So my assumption is we're going to go one witness at a time, not one criterion at a time. So we'll start with Mr. Avery. Is that okay?
Yes.
Mr. Avery, good morning.
Morning.
You're Hazellett's retained project manager and owner's representative, correct?
Correct.
And your role includes coordinating the design and engineering team overseeing the Act 50 application?
Correct.
And you're not an engineer, are you?
I am not.
You're not a traffic engineer?
I am not.
And you're not an architect?
I am not.
And you're not offering any soil classification opinions?
I am not.
And you're not offering any fire code or occupant load opinions, are you?
I am not.
And we've talked about it already, but just for the purpose of the record, you're acknowledging that to the extent there's a difference in the capacity of the restaurant, we're going with 40 seats, not 48 seats, correct?
That is correct. 40 seats.
And do you know, have all of the analyses that have been done relative to parking, traffic, and the like been done based on a 40-seat restaurant, not a 48-seat restaurant?
To my knowledge, yes. And given that we're reducing the number, if there was any errant or stray analysis on a 48 and we've been reduced to 40, then that would be an improvement on the condition.
Yeah. You say in your testimony that the 20 rooms were deliberately selected to feel residential rather than institutional, correct?
Correct. The scale of the architecture was intended to feel more residential in nature.
But you'd acknowledge this is a commercial hospitality development, not a residential development, correct?
That is correct.
And you did not prepare the traffic memorandum, did you?
I did not.
but you do understand it models 20 rooms using the ITE code for single-family detached housing, correct? And if you don't know, I can.
I would need to confer with our consultant.
But you'd agree that in general, the project is characterized elsewhere in the submitted documents as non-residential, fair to say?
That is correct.
And the prior motel was removed in 2017, correct?
Correct.
And are you familiar with that demolition permit that was discussed at some length at the zoning hearing, but also is mentioned in this
I'm familiar with it. I was not a part of that process.
Do you have a sense of whether that demolition permit has a limitation on when reconstruction can occur in that area?
Objection, I'm not sure what criteria that's relevant to.
Well, it's in our view, it's relevant just to the general question of whether or not the project can be constructed in the time frame that we need. But I'll withdraw the question. It's something we can address in the briefing. There are no existing lodging buildings on the waterfront parcels of the project where the project would be located today, correct?
No existing lodging buildings, no.
Yeah. And the current proposal would place 5 cottages, a 3-level main building from the lakeside, a bathhouse, driveways, utilities, and new landscaping on the parcels, correct?
Correct.
So you'd agree that the proposal creates new construction of buildings on what is presently a relatively open lakeside slope with trees, correct?
The project will be constructed on a parcel of land that does not currently have roadside development on it.
And your testimony does not quantify the former motel's actual room count, gross floor area, restaurant capacity, event capacity, or peak parking demand, does it?
No, it does not.
And so the commission does not have a like-for-like comparison of the historic motel's intensity of use as compared to the current proposal, correct?
Correct.
And guests of the project would be expected to park on the south side of West Lakeshore Drive as has been described, correct?
That is correct.
And then they would cross West Lakeshore Drive to reach the inn facilities on the north side?
That is correct.
And the application identifies 67 new parking spaces on the Hazelett industrial side of the property?
67.
I believe that's right.
Correct.
And then it also identifies space for a future 50-space reserved parking lot if needed?
Correct.
But whether and when that reserved parking would be built is not specified in the testimony, is it?
No.
And there's no event day parking management plan that identifies which spaces are reserved for in-guests, restaurant patrons, attendees, staff, marina users, and Hazelett employees, correct?
Correct.
And do we have the site plan?
Yeah.
Mr. Simon, it would, as we're doing that, it would help if you can frame your questioning, or as you start a new line of questioning, just tell us which criterion you're focusing on. That, I mean, that, I'm not going to hold you to that strictly, but
Sure.
it will generally help our comprehension and that of all the participants.
Yeah, that'll be easier with the other witnesses. As Mr. Avery said, he does a lot of overview, so some of this is sort of overview, and really relates just to the adequacy of the application materials, the information provided.
If I could add
Yeah.
to your last question.
Yeah.
The parking analysis was done by TJ Boyle and Associates as a cross-parking analysis, taking into account all existing activities on the site as well as proposed activities on the site. So Jeremy would be able to answer questions specifically related to the parking analysis.
Thank you for that. Just on the site plan, isn't there going to and this is on criterion 5, obviously, aren't there going to be parking spaces that need to be utilized by guests that are located to the south of what's identified on the site plan that's on the screen?
South, where,
Yeah, to have,
South down.
to have sufficient parking. Do you agree or disagree with me that sometimes guests will have to park in other portions of the Hazelett lots other than the new parking areas?
I suppose it is possible, but again, we've done a parking analysis that is site-wide.
Right, and does that not require ultimately 147 total spaces available for the project?
That was that.
I mean, we have over 300 available.
Right, but assuming you need at least 147 for the project and recognizing you have over 300 available on the site, some of that parking that would be relied upon would be to the south of what's shown as the new parking on the site plan.
He's just saying that there's a scenario where people here might have to park over here.
That is correct.
And there's no,
Could you tell us which way is north and south on this? North is up, or?
I think for the purpose of discussion, we should just call it up. It's sort of 45 degrees.
Up and down?
Yeah.
yeah, when I refer to the site plan, I'm always referring to up, north is up,
The
down
lake
is south.
is north, the factory is south.
Correct, yeah.
Got it.
Yeah, and this is one of those roads where some people, I think, have said east-west in their testimony, and some have said north-south. So just at a 45-degree angle, so just to make it more confusing.
So Mr. Abe, do you mind if I approach the site plan? Is that all right?
Watch out for all the corners.
Careful.
Yeah, I'll go around. So Mr. Avery,
We forgot to have a sign our waiver.
if parking back in the southern side of the site might be utilized and considering that the existing wet pond, and this goes to criterion 1 as well, that's going to turn into a gravel wetland, correct?
That's correct.
Gravel wetland too.
Well, and hold, so right now, Ben,
I should respond.
Yeah,
that should be answered.
My bad.
And if you can't answer,
Yeah.
you should indicate which witness would best be able to answer.
Perfect.
So why isn't any of this other area that would be utilized for project purposes included as part of the project site?
It's existing parking. It's existing impervious surface.
And the change from to a gravel wetland, that doesn't qualify to get the pond into the project site?
That would be a question for Scott.
All right. And there's no identification of which additional parking would be available to hotel guests versus Hazelett employees, is that correct?
Again, I would defer to TJ Boyle's cross-parking analysis.
All right, thank you. You described the project in your testimony as reducing lakeside parking in impervious area in certain locations, don't you?
Say again?
You described the project as reducing lakeside parking and impervious area in certain locations, correct?
Let me review.
And what page of his testimony are you referring to, just to?
Just a moment.
If you are referring to the existing parking that is located for the mooring field, that parking area would be reduced as part of the plan in favor of the proposed parking on the south side of the street.
And you defer to the engineer for the actual impervious area calculation and stormwater treatment analysis, correct?
Correct.
And you cannot tell the commission Sorry. You cannot tell the commission from your own personal or technical knowledge which reported impervious area figure is the final governing number for the project. And you cannot tell the commission from your own personal or technical knowledge whether the proposed treatment system treats all drainage reaching the relevant outlet. Okay?
Correct, I would defer to the civil engineer.
Thank you. You recall in your testimony that you described a reduction in square footage relative to the development of the project? Sorry, reduced development?
Could you direct him to what page?
Yeah, I'm not sure. I said, me a moment. I thought I had that up, but I apparently closed it. Yeah, I got it. So, for example, in section 3 of your testimony on page 3, you say that there was a deliberate design choice that reduces development intensity and impervious cover on the water side of the road.
So it's a general statement that as opposed to, from a design approach, as opposed to a monolithic structure, we intentionally chose smaller cottage-sized structures, which were intended to reduce the visual impact.
But you'd agree with me that the project does not itself reduce the intensity of use at the site. It increases the intensity of use and development at the site, correct?
I wouldn't say that. The allowable square footage is the allowable square footage.
Well, but as compared to what's there now, a hillside with trees versus 7 in-units, that's an increase in development of the site, and isn't that fair to say?
Yes, the post-construction impact would be an increased impervious surface to what there is there today.
And just overall development as well, correct?
Correct.
And the original proposed restaurant was 3,000 square feet, right?
I don't recall what the original proposal was.
All right, but the 3,200 or 32,000 square feet is not a reduction, that's an increase over whatever was previously submitted, correct?
I can't speak to what was previously submitted. I don't know what you're referring to.
All right. And with regard to the project's impact on water quality, and you may not be the right person to ask this, but just given that you're the sort of the overall sort of shepherd of the project, are you aware that even with the site balancing treatment, that the project would add phosphorus load to Lake Champlain, the net addition of phosphorus?
I would defer any water quality questions to the civil engineer and our stormwater permit as approved.
Are you aware of the current situation with Lake Champlain and the fact that there is a phosphorus loading problem?
I have no technical awareness of the situation.
Are you generally aware that the state has spent a lot of money trying to reduce the phosphorus in the lake?
Again, I have no specific details as to that item.
Do you think phosphorus is a problem in Lake Champlain?
Objection.
Well, I'll rephrase it. Do you think of phosphorus as a pollutant?
Objection. His unexpert thoughts as to whether or not phosphorus is pollution is irrelevant.
What it goes to is really credibility, in the sense that if the idea here is that 7 structures and what we view as pretty significant development, if the applicant's position is that really doesn't have any impact on the lake, or it's de minimis, I think it's fair for us to understand that characterization, because it goes to whether or not the commission can rely on the applicant's characterizations of the project.
I mean, they aren't relying upon the analysis of this non-expert witness for the purposes of compliance with regulatory standards relating to water quality in the lake.
Well, Mr. Avery, if you can answer the question, answer it. If you can't answer it, or you need to defer to another witness, just make that clear.
I have no direct technical testimony to offer. In my role here, we retain a qualified civil engineering firm to create a stormwater plan. We then rely on the state stormwater permit as issued and entered here to address these items.
All right, thank you. I'm just going to check. Were you aware of, or did you see the comments from A&R requesting additional information?
I am.
And I guess we just heard a little earlier that you'd agree with me that no additional information was provided in response to A&R's request prior to, I guess, this past Tuesday?
That is correct.
What's the reason that A&R's request for information went unresponded to until Tuesday?
We received a formal request from Jen and Mojo on Monday. I conferred with Scott, and we responded on Tuesday.
You had not received any prior requests, or are you just saying you had not received any prior formal requests?
We had, I believe there was a email question at one point from, might have been from Tina Heath, but we had not formally responded to that.
Why not?
Objection. I'm not sure how this gets us to satisfaction of the criteria.
I think again, it goes to this question, whether the applicant's being forthright in the information that they're providing, given that they were asked information and didn't respond.
For objection, that's a mischaracterization of what happened. Mr. Avery just testified that the email was received on Monday and a response was provided on Tuesday. If 24 hours isn't quick enough, then there's a lot of problems with satisfaction of active budget criteria across the state.
Right, but we're talking about prior, he said there was a formal request, but he said there was an email received previously.
Again, the procedural record will be the procedural record. I thought this was an opportunity to present evidence, not have arguments about procedure.
We will have an opportunity to ask Ms. Mojo about some of that. So, Mr. Simon, please
I'll move on.
move on.
Thank you. And Mr. Avery, would you agree with me that conceptually, from a physical standpoint, the project, there's enough acreage on the south side of West Lakeshore Drive where the project could be located physically on the south side of the road, correct?
What's the question?
That from like a physical standpoint, it would be possible to locate the project on the south side of West Lakeshore Drive, correct?
I cannot speak to that.
You don't know, what's the acreage on the south side of West Lakeshore Drive?
It's, again, if you don't know.
Yeah,
If you don't know, that's fine.
actual acreage could be answered by someone.
Right, but if they represented that there's upward of 150 acres that's owned by Hazelett on the south side of the road, you don't have any reason to dispute that there's that order of magnitude of acreage, correct?
No, the parcel size is the parcel size and the property records.
Yeah, and so as a matter of physics, theoretically, you could locate the project on the south side of West Lakeshore Drive, correct?
Objection, relevance, and this also isn't an opportunity for the opponents to redesign the project. The application presents a project, and the question is whether that project, as proposed, satisfies the Act 250 criteria, not whether the opponents would like to build a different structure.
Well, it goes to 1F because there's a necessity requirement that it necessarily be located on the shoreline. So if they have other property where they could locate a project not on the shoreline, that's relevant to the necessity question.
Relevant to which?
The question of necessity under 1F, whether it necessarily needs to be located on a shoreline?
We would again point out this is not virgin land. This is land that was previously developed.
Well, I think we have enough testimony so far, and I'm sure you'll cover with some other witnesses, Mr. Simon, about whether, and the commission has been to the site and has seen both sides of the road, so I think we know what might be possible.
Thank you. And Mr. Avery, does the application or any of your testimony address the public investment that has been spent in cleaning up Malletts Bay?
None of my testimony that I'm aware of.
And are you aware of any way in which the application has addressed that issue?
Just specific to water cleanup?
Yes, the public investment question relative to water cleanup of Malletts Bay, yes.
I would defer to the civil engineer just to.
All right, thank you. I think that's all I have. Thank you. Oh, sorry, I have one other question. Is there's been discussion about the manager's unit? You know what I'm referring to when I refer to the manager's unit?
Yes.
I think it's in dwelling 5 or,
Yes.
sorry, maybe 3. Is that residential, that unit intended to be residential?
No, that is a part of the commercial venture.
Thank you.
Council, I don't think in our overview of the process we got to the level of detail of whether the redirect would occur now or after Attorney Bryce has completed all of his cross-examination of all of the applicant's witnesses. Do you have a strong feeling one way or the other?
I mean, it probably makes sense to do it at the time that after the cross-examination while the testimony is fresh in everybody's mind. We don't have any redirect questions.
Questions of the witness? Then you can proceed with your next witness.
All right, our next witness is Jennifer Connolly with respect to criterion 5. We'll make her available
for questions.
And remember to speak up, Ken.
Yes, I will.
I want to give Mr., what was it? Cloud? Did you go to Twinfield?
Oh, sorry?
Did you go to Twinfield?
No, we went to the
Oh,
academy.
you went to the academy. I knew I recognized you.
Thank you, Mr. Simon. I think our order of business was going to be that the state statutory parties could go first in asking this witness any cross-examination types of questions.
That's why I was deferring
Right,
to Mr.
so do you have any for this witness?
Chris Cloud, the Light Agency of Transportation. I do not have any questions.
How about you, Ms. Mojo?
Jen Mojo, Agency of Natural Resources, no questions.
Okay.
You can move up to this chair too, here on the end, Jennifer, just because the.
To help me forget.
Yeah, there we go. The witness is available.
Thank you. Jennifer Conley?
Correct.
You studied the West Lakeshore Drive segment along the site frontage and the existing Hazelett driveways, is that right?
Correct.
You did not perform an intersection capacity analysis at Bayside, Blakely, East Lakeshore Drive as part of this testimony, did you?
I did not.
You studied typical weekday AM and PM peak conditions,
Correct.
and your counts were collected on Tuesday, April 29th, 2025.
I don't recall the day, but yes, it was in April.
And you did not conduct a count during a summer weekend, a wedding, or any other major event where you would have full occupancy conditions at the end, did you?
I did not, but I did follow the standard protocol for adjusting April data to a summer, to a peak condition.
That's a theoretical adjustment, right?
Well, it's a physical adjustment based on what nearby roads show that factor to be.
Why do those numbers come out so differently from other traffic studies that have been done in the area?
I can't answer that question.
You did not conduct, and you can explain if I'm mistaken, but it doesn't sound like there's an analysis of what a traffic count would look like if the project were built and the restaurant, event center, inn, marina, and Hazelett employment demands all peaked simultaneously, correct?
Not entirely. Whatever was happening at Hazelett was happening when we counted, and whatever the existing conditions. So if there were, as people were coming and going on the day we counted, everyone was included, and we did an analysis of that with a very conservative estimate of trips to the site for both the restaurant and for the hotel units.
Have you ever driven this section of West Lakeshore Drive during the summer?
I have.
And have you ever observed traffic backup in that area?
I have observed a number of people turning in and out of different locations. That does slow down the people behind them, yes.
And the project would result in additional turns from what exists currently, correct?
Correct.
And to be clear, because of the configuration of the parking, there'd be trips where people would be turning into the project site to the north, and then would have to come back out and cross over to get to the south parking spaces, correct?
I analyzed it that way, but the likelihood is most people would likely just park on the parking lot side and walk across once they were familiar with the site. But to be very conservative, I assumed absolutely everyone did a drop off and then came back across just to almost double count those trips just in case.
All right. And you used ITE, single family detached housing, LUC 210 for the 20 dwelling units, correct?
I did.
And the applicant calls this project a commercial hospitality project, not a residential project, correct?
Correct.
And you used 40 restaurant seats in the trip generation calculation.
I did.
And your testimony says the current total is 45 AM and 53 PM peak hour trips.
I would have to refresh my memory. We're looking at the exhibit, but that sounds like the correct number, yes.
And does that assume maximum restaurant occupancy?
That is, the way ITE works is it includes hundreds of data points for different size restaurants and calculates counting literal driveways to determine the number of trips per seat that come in that very highest hour. So I would guess some of those data points were full occupancy, whereas some may not have been.
And why is IT single-family detached housing an appropriate measure of traffic for a commercial project?
The trip rate for Land Use Code 210 for housing is twice the rate of the per unit for hotel. So it is an overly conservative way to analyze the site. In addition, by coincidence, it also seemed appropriate based on the size and the scale.
Right. You say in your testimony the event use is not an everyday occurrence and therefore is not typically included in daily trip generation. Is that accurate?
That is correct.
And so how does that, is that not inconsistent with the idea of having traffic counts that contemplate maximum occupancy?
We typically in traffic engineering, and my colleague from VTrans can verify this, VTrans does not want you to design necessarily to the very, very busiest day of the year. If that were the case, for example, going to and from Stowe, you would have a 3-lane road, in each direction. You don't design your infrastructure for the very, very worst case scenario. You design it for a very conservative scenario, but you don't account for something that isn't in your typical weekday during the typical peak month.
And you also conducted a sensitivity analysis for an event, is that right?
I did.
And that estimated 9 AM and 7 PM peak hour trips, correct?
That is correct.
Wouldn't the events that would generate the most traffic not likely occur at 9 AM?
That is correct. They may not occur at 9 AM, but if this were used as a conference facility, it could. And so the data includes trips. It doesn't assume it's only a certain type of trip.
And that sorry, I didn't cut you off.
I'm sorry, just it doesn't assume a certain type of use. So it gives you, if there is an AM event, that would be the trip generation in that time.
And that doesn't tell us what it would look like if it were a lunchtime event or something. It only analyzes that one.
Yes.
And it did not model combined use of the restaurant, bar, decks, cottages, event rooms, and overflow parking at the maximum simultaneous capacity based on what you just said. That's not the way it's done.
The only thing that was not included in there was, the event at that same time.
And this analysis also did not include a parking surge calculation analysis for guests directed to overflow employee lots.
I did not do any parking surge calculation, no.
And it did not quantify vehicle or pedestrian movements between remote overflow parking and the end, did it?
No.
Could we put the site plan back up? Do you mind if I approach it again? You were present when I was questioning Mr. Avery, correct?
Yes.
And so you heard my questions about, when this goes up on there, we can talk about it.
It's up.
Oh, there we are. So if we could scroll down to the southern part of the Hazelett property. So you agree with the testimony, or you accept the testimony that there is going to be parking needed in these existing parking areas that are to the south side of the site?
I heard that it could be, yes.
Yeah. There's no added lighting for that parking, is there?
I don't know.
So your analysis of lighting, though, only really addresses the newly created parking just south of Lakeshore Drive relative to the lighting, correct?
I did not give it any lighting.
Oh, you didn't give it lighting, okay.
Okay.
But your analysis only addresses the area just south of West Lakeshore Drive, crosswalk, and then the northern.
As a traffic engineer, that is what I am. It's really what traffic, pedestrian or vehicular, is occurring, crossing, and influencing the public street.
And so that analysis, though, does that include recognition of the use of these other spaces throughout the site?
Not in a direct way.
Okay. Thank you. And so then that also would not quantify vehicle pedestrian movements between these lower southern parking areas and the project site, correct?
Yeah.
And the proposed project places principal parking across Lakeshore Drive from the inn, as we've discussed, correct?
Yes.
And that requires guests and other patrons to cross the roadway on foot, correct?
Yes.
You know that the road has narrow shoulders, no bicycle facilities, and no pedestrian facilities on the north side, correct?
Correct.
And you acknowledge that V-Trans crash history recorded 18 crashes over 6 years in the vicinity of the project site?
Yes.
And 2 of those crashes occurred when a vehicle stopped for pedestrians in a crosswalk and was rear-ended, correct?
Yes.
Can we expect more of those kind of incidents with the proposal that is before us?
And I would make 2 points. The first is that it shows the system worked in that the car stopped for the pedestrian. The lack of attention of the secondary driver, unfortunate, difficult to control. But in this situation, to try to mitigate that, there will be signage and an RFB, which hopefully raises first the awareness of the crossing location, and second, really raises hopefully the awareness even of the secondary driver with the flashing lights and with the signage.
So do you agree or disagree with me that considering that history, we could expect additional incidents like that in the future if the project's built?
I disagree.
You disagree just on the basis that there's going to be a crosswalk?
I disagree for 2 things. One, those 2 events do not show a particular pattern and are not at this location. So it's not as if there was a crosswalk here that was already showing that there was limited sightlines or another deficiency that needed to be addressed. The sightlines at this location are very long, and we're doing everything in our power to raise the ability of the drivers to see the crosswalk and to have an added awareness of a pedestrian. So I see no reason to assume that 2 crashes over a 6-year period indicate any sort of a pattern or any sort of a deficiency at this location.
All right. So if you're wrong and there's an increase in crashes or other dangerous incidents after the project's built, there will be no recourse for that, would there?
Objection, irrelevant.
What if you're wrong?
But hold on.
I think I'll sustain the objection.
Have you ever, would you agree with me that you may be wrong?
Objection.
I don't think that's in order, Mr. Simon.
Is there a roundabout that's going in or that's gone in at West Lakeshore?
There is a roundabout planned at West Lakeshore, yes.
And isn't that going to change the dynamics of this area, the project area?
The roundabout is being designed to calm traffic and slow down the traffic that travels through this area, but as has already been discussed, during the summer peak period, with folks turning in and out of driveways, traffic already gets calmed significantly. I see the most significant impact of the roundabout to occur in the off-peak times, later in the evening or a non-peak month, when it will have that benefit. Instead of a green light that people travel through at a high rate of speed, it will be designed to slow the traffic down in this corridor.
Couldn't the roundabout also create more traffic volume because there wouldn't be a traffic control device like a stoplight that limits the entry into this section?
No, I mean, it's the same amount of traffic. It meters it by just folks yield to each other. So it just processes it in a different way, but it does not change the volume that passes through.
The existing crash history you relied on necessarily predates the new project's additional pedestrian crossing, correct?
Historic crash data?
Yeah.
This, yeah, relied on history, yes.
Right. And a finding that the segment in front of the project area is not a high crash location is not the same as a finding that a new generation of repeated crossings creates no additional safety risk, correct?
Those are two very different things. The historic data shows that there isn't an existing issue. Our evaluation of where a driveway is located or a crossing is located is to look at the existing constraints and whether the sight lines are adequate to allow for those things. Taken together, though, they are a fair predictor of the future and what can be expected.
And your conclusion about the reduction of risk after the construction of the project, that's a professional prediction. It's not based on operating data from this proposed crossing, correct?
There's no way to have operating data of the proposed crossing.
So it's a prediction.
Yes.
You did not evaluate a raised crossing, pedestrian refuge island, staffed crossing, or any other event day traffic control measures, did you?
No.
And you didn't analyze the difference between the proposal and putting in an underground pedestrian walk, did you?
No.
You did not quantify nighttime pedestrian exposure from remote or overflow parking areas, did you?
No.
Regarding the level of service versus safety and accessibility, level of service is principally a measure of vehicular daily and operating conditions, correct? Or sorry, delay in operating conditions, correct? A LOS A or B result does not itself assess the ADA accessibility of the route from each parking area to the building, does it?
No.
And it doesn't demonstrate safe bicycle accommodation, does it?
No.
And it does not itself establish the safety of elderly, mobility impaired, intoxicated, or unfamiliar guests crossing after dark, does it?
No.
You did not perform a ADA route analysis, did you?
No.
And you did not provide a bicycle level of traffic stress analysis, did you?
I said no, I'm sorry. You may not have heard it over the call.
Those are things that can be done though, right?
You can do that for any segment of roads, yes.
And you did not analyze whether all parking that might be used for the project has a continuous lighted pedestrian route to the end, particularly the parking overflow to the south, correct?
No.
Did you, in your traffic analysis, did you use 60 guests or 20 guests for the event space, your overall analysis?
I would have to take a look.
Your capacity of the event space is 60, right?
I don't recall the capacity of the event space. Yeah, 60 seats was what was analyzed.
But don't your numbers only work out to 20 actual?
17 in the PM peak hour.
Yeah, okay. So
because if there is an event of that has the potential capacity of 60 seats, one, not everyone arrives at the same time, and there is some assumption of whether the peak, all 60 people will be there at what time. For example, if there is a conference, as I mentioned earlier, the conference may be done at 3 and people may leave over time, or vice versa, if it, for arrival patterns. Not everyone is, all 60 people aren't arriving in any 1 hour, and certainly not typically in the peak hour.
well, but if an event is scheduled for a particular time, don't people arrive close to that time?
They do, but I don't think any programming has been done for the facility as of yet. So I used statistical, trip generation data for it.
So if there are events that start at a particular time that involve people arriving around the same time, your analysis does not address that.
It does not assume that every day of the year there will be an event that overlaps with the PM peak hour, that all 60 people arrive within that hour. No.
And does your analysis contemplate employees contributing to the traffic?
It does, because in the IT trip generation, as I said, it is like a driveway count at these facilities. So anyone who arrives during that highest hour is counted. But as we know from visiting restaurants, the employees tend to be there before us. Or if they're going to a wedding, the employees are there. They arrive during a different hour than necessarily the peak loading of the event.
So your analysis relies on statistical assumptions rather than actual usage based on capacity and the number of people who could be at the site at a given time?
No, it is based on the ITE trip generation manual, which determines those trip rates based on existing sites.
But not this site?
Not this site.
And not this project?
No, but it is for events of 60 seats, 60-seat facilities.
Did you ever look to the actual capacity of the project to address, to analyze the numbers, or like the maximum capacity, or does that not have a role because you're just relying on statistical?
So the IT trip generation manual looks at facilities, as I said, and determines what the trip rate is in that PM peak hour for similar facilities of that size. It's a trip rate per seat. So it is for 60 seats, which are proposed at this facility.
When you say of that size, what do you?
60 seats?
Okay, so so not square footage and not capacity of the whole project.
Well, we did, as you know, also look at, so that was for the event space.
Yep.
And then we did for the number of seats proposed in the restaurant. And then we also did trips for the residential component. So yes, we did it for each of the components that are being proposed for the site.
So is your analysis in any way based on square footage of the project or just capacity?
It is based on capacity.
Thank you.
Sure thing.
Nothing further.
We have no redirect questions. Oh, I'm sorry. Just to clarify one issue about the scope of your analysis, you were asked to evaluate traffic impacts as opposed to designing the capacity of the parking facilities, correct?
Correct.
But your analysis takes into effect the traffic that you anticipate could be generated by this proposed project using standards developed in the ITE manual and V-Trans.
Correct.
Nothing further.
I just have one question on the accidents, the two accidents.
Yes.
What was the time frame of those two rear?
Sorry, what's that?
The two rear endings on that, and I'm assuming it was in that stretch of road, right?
Right, so it was in a 0.3 mile segment, and actually Chris Cloud may be the one who could answer better questions than me. It was part of the V-Trans analysis, but it was in a 0.3 mile segment of West Lakeshore, and it was over a 6-year period.
And maybe Chris is the person to answer this too. What would be a typical in that type of commercial or residential area? What would be a typical number of rear endings over a 6-year period?
That is a good question, and I don't think even Chris could answer that. But his analysis did look at high crash locations throughout Vermont. There is a high crash location rate, and this is significantly below that threshold. That's when V-Trans gets concerned and starts to look at mitigation to address crashes.
Thank you.
We'll move on to the next.
Can I just ask you one recross based on the questions that were just asked? Is it true that the International Institute for Transportation Engineering Institute indicates that that traffic analysis should be based on square footage?
No, it depends on land use. When you go to the ITE, it gives you a range of different variables, but depending on what you're proposing, you look at the trip rates, if it is available for square footage, and if it is available for whether it's residential units or seats, and you find it's a curve, and you find which variable better fits your size facility.
Based on that, you did it based on capacity, not
Units
square
and
footage.
on seats.
Reasonable minds could differ whether that's the right approach.
Typically, using the higher numbers is the correct approach.
All right, thank you. And then regarding the chair's or the commissioner's question, if this, hypothetically, if after the project were built, this became a high traffic or high accident location, what's in place through the state to address that?
Well, one of the ways that you hear where there are, typically, if there is a high crash location, it has to do a lot with visibility and being able to anticipate a hazard. In this case, the sight lines are there, so that wouldn't be something that wouldn't be a type of mitigation. But the state does take a look at if these driveways were a high crash location, they could do things to attempt to slow the traffic, typically calming the traffic, slowing the traffic to, again, allow more time to see a hazard. That's one of the ways that you mitigate a crash. There's a number of different things that you can do.
And for purposes of the crosswalk, one of those things that you can do to mitigate danger and risk is the raised crosswalk, right?
That does, by slowing the traffic, that's one of those traffic calming measures.
Thank you.
I think we can move on to your next witness for cross-examination.
Thank you.
Our next witness is Jeremy Owens, the landscape architect, and he is testifying with respect to criteria 1F and 5.
Are there any exhibits that you would like me to pull up for visual purposes?
I think it depends on the questions that might be receiving.
And we make.
Clow or Ms. Moza, do you have any questions for this witness?
No.
First of all, these have no questions.
Okay. You may proceed, Mr.
So, go ahead.
Yes, please.
Mr. Owens, you inventoried 124 trees greater than 1 inch caliper within 100 feet of the shoreline at the site, correct?
Someone from my office went to identify trees on the site, and many of those were based on what was found on the survey, which was performed by Krebs and Lansing. But their job when they went out was to verify as well as they could that that's where those trees were located and whether they could identify or approximate the species.
At some point, I'm going to need to be able to share my screen.
Okay, what we can do is make you a presenter on Teams, and then you can share your screen from that. Is it one that has been submitted already?
Yeah. Photo of the project site from the lake.
Do you know what exhibit number it is?
I think it went with Maryland Souls. Hold on.
I have a few images here that are separate exhibits. I can pull them up and see. Is this no closer?
No, the closer.
Yeah.
If you want, I can,
Do you know the image number associated with that particular?
let me,
Yeah, like if there's not, I don't mean the exhibit number, if there's like, do you know which, because there were a bunch of images that have unique numbers attached to them?
Yeah.
I think they're there.
Yeah.
50, 64,
You just found it, isn't that the one?
no,
you-
I found it, but that's on my, that's not the,
We can, right, so Steph is gonna make you a presenter and then you can share your screen.
I did.
Oh, you did, okay, so you're all ready to go.
And for the record, if it has already been filed as an exhibit or if it's part of an exhibit, that should be referenced. If it's a new exhibit, then we'll have to deal with it as a new numbered exhibit.
I will, I'll see if I can find which exhibit number it is.
There it is, sideways.
this way, so it's easier to see.
I have a photo that's a close-up that shows the dock coming out.
Yeah, that's not, I mean, this is basically, yeah, the one that's up there. Is that my screen?
That's your screen, yeah.
That's weird. This screen is showing it.
Yeah, it's lagging. I think.
Maybe we all need to go like this. Looks good to me.
Well, I just think it might, oh, I see why. You know what it is? It's the screen sharing function of Teams is really strange. It silos you. So hold on.
So is this part of the testimony that has been,
This was previously submitted, and I'll identify what the number was. I just have it in a different form that's more handy.
This is not part of Mr. Owen's
No,
pre-trial testimony, but it relates to it.
it relates to it, and it was submitted by the, by my group, and we'll identify for Caitlin where it is. It's just a photo, a somewhat near-shot photo of the project site.
well, if it is in the record, we'd like the clarity of what exhibit, that's the purpose of having things marked as exhibits in advance. I know that there's some images marked number 79 through 87. Is it one of those? If you have an image number on the file, it could be identified pretty easily.
I'm gonna have, I don't wanna take up the time right now doing that, so I can ask this another way. The issue that I just wanna get at is that, of the project site, the trees that are located there, most of those trees are gonna be removed, as part of the project, correct?
I believe so, yes.
And, there's about 5 trees that'll remain in the central project area, plus the cedars on either side.
The vegetation proposed, or I'm sorry, that exists along the far west and far east property lines for both of these projects will mostly remain.
Right.
And much of the remaining vegetation will be removed, some of which is within the road right-of-way, so that we can have ingress and egress to the site, and then some of which is near the road, and then some of which is on the existing embankment.
All right, thank you. And your landscape plan L1.1, that identifies the trees that are staying, correct?
It may have a symbol for some of the trees that are staying, but it doesn't give any identifying information.
Well, but it has the trees that are staying marked in a different color, correct? There's like a symbol used, a black symbol. Oh, that's the image that's up there now, yeah.
Yeah, without color and basically just black and white lines.
Yeah,
Yes.
So that's those 5 trees on the central part of the project site plus the cedars off the other side, correct?
I don't know if I would say it's 5 trees because sometimes we just try to prevent a lot of overlapping of those black and white line symbols because it becomes very messy. And we're trying to prep these plans so that they read well.
But so all those other trees that are on the site, you can see on the photos of the site and that the commission saw when they visited the site, all those other than the ones that are marked on this diagram as staying, all the other ones are being removed, correct?
I believe I already answered that a lot of the trees are being removed, yes.
Right, all the other ones other than the ones marked on this site plan is staying.
I haven't done an analysis of this plan to be able to answer that question.
All right, thank you. Those trees are not invasive species, are they?
Some of them.
Some of them are. And you, assuming that you're to remove around 54 trees greater than 1 inch caliper within the 100-foot setback, is that right?
Yes, that is what we counted.
And you propose planting 64 replacement trees in that setback zone?
Yes.
And the newly planted trees and shrubs will not immediately provide screening, root structure, canopy, or habitat characteristics of mature existing vegetation, correct?
When you refer to screening, what are you referring to?
Visual screening of the buildings from the road or the lake.
Some of them will. Some of them will be low enough so as not to provide screening until several years in the future after they've become more mature. But we are able to plant close to the foundation of the buildings. And so some at the time of planting will provide screening.
But your overall mitigation conclusion depends on successful installation, survival, and maintenance of the plantings, correct?
The mitigation, as it relates to criterion 8 and the Acquici test, anticipates that plants that die would be replaced.
But you did not specify long-term survival percentages, a replacement schedule, or performance-based mechanism.
No, that typically would be done towards the end of a project during construction and any agreements, but the expectation is that if a plant dies or is otherwise unhealthy, that they would be replaced, usually in conjunction with the installer to install those plants.
Right. And as you said, you sort of intimated you performed a Acquici analysis relative to the proposal, correct?
That's what's in my testimony, yes.
And you conclude the project will have an adverse effect on scenic and natural beauty, correct?
I did.
You also say the project will be a noticeable change from nearby portions of West Lakeshore Drive, correct?
Yes.
And you state the project will increase the presence of buildings visible from the roadway and lake, correct?
Yes.
And you state there will be an apparent increase in building density from West Lakeshore Drive, correct?
Adjacent to the project, yes.
And you regard the adverse impact as low, but you still conclude it's adverse under the first part of the Acquici analysis, correct?
As stated in the testimony, yes.
And your ultimate conclusion is that it is not undue depends in part on your opinion that the applicant has taken all generally available mitigating steps, correct?
The applicant has taken reasonable mitigating steps, yes.
And you did not evaluate any alternatives that would reduce the number, gross area, or lakeside visibility of the proposed buildings, did you?
I'm sorry, can you state the question again?
You just compared what was proposed. You didn't do any sort of comparative analysis of what the analysis would look like with, for example, less buildings.
That's correct.
And you did not prepare a comparative visual analysis of a smaller building plan, correct?
That's correct, nor am I necessarily expected to.
And you did not quantify the visual effect during the interval after clearing and grading, but before plantings mature, correct?
Correct.
What's that?
I'm sorry, can you ask the question again?
Yeah, you didn't do any qualitative visual analysis of the aesthetic impact after the property's cleared and graded, but before the plantings mature.
You mean immediately after installation of
Correct.
plantings versus
Right.
more mature? No, I did not.
Thank you. And in regards to the visual analysis, I'm going to share my screen if I can. So, Exhibit A, the applicant's Exhibit A, shows a couple, the nearby use of the Bay Harbor Marina, correct?
I believe that's the name of it. This is the one immediately west of this project site.
Is this, oh,
Yeah, this
an
is,
exhibit that's been filed, and what's the exhibit number?
it's Exhibit A, petitioner's Exhibit A. So you'd agree with me that at least the buildings that are depicted in Exhibit A, those have less of a visual impact than the proposed project, correct?
I didn't analyze the visual impact of an adjacent building.
Well, so what is the relevance to nearby buildings to the Queechee analysis?
So the Queechee analysis is asking for the character of the area, including nearby buildings, what the materials are. Doesn't specifically ask about the size of the buildings, although those are things that you would typically state in an aesthetic analysis. You'd look at colors. You'd look potentially at what open space remains, if you can determine so for nearby buildings.
Right, so if we look at Exhibit A, which I just had up, and now I'm looking at Exhibit B, aren't these exhibits provided to show the character of the area?
These exhibits are provided to show some of the character of the area. It's not exhaustive. There are other buildings that could have been provided, but we're not trying to waste anyone's time by submitting a picture of every single building. So these are nearby buildings that are somewhat similar in size or structure or orientation or the way in which the buildings relate to the water in Malletts Bay.
So none of the buildings that were included in Exhibit A, B, C, or visual images in Exhibit D, none of those show a visual impact commensurate with the project's proposal of 7 buildings on a single lot, correct?
Objection. I'm not exactly sure. I don't understand the question, so I suppose if the witness does, he can answer.
I'm unsure if you're asking me if I did an aesthetic analysis on the adjacent buildings. And if that is the question, then the answer is no.
The question is, do your exhibits A, B, C, and D, are those submitted to support your character of the area analysis?
Those are not submitted by me, as far as I understand. They're submitted to help the commission understand what existing buildings are, or at least have reference to them. I didn't specifically submit additional photos because I felt like those were sufficient.
Right, so you thought those photos were sufficient to establish the character of the area. Is that fair to say?
To reference the character in the area.
What's the difference? What do you mean by reference the character?
The character is itself. I don't need to establish it.
Okay.
These photos reference some of that existing character.
And you agree with me or disagree with me that none of those photos show 7 buildings on a single building lot?
I would agree that none of those photos show 7 buildings on an existing lot, with the caveat that I don't know exactly where the property lines are for all of these different buildings.
Okay. And do you agree with me or disagree with me that the project would actually be different from the typical land uses in the area? From a visual standpoint?
Actually, if you look at my testimony, I talk about how many of the buildings have different architectural styles, colors. If you haven't read it, I suggest that you do. Maybe that would answer the question.
Well, I read your testimony. What I'm trying to understand is, well, maybe I can put it this way. Why is there an adverse aesthetic impact?
I mean, you've already asked me that question, but essentially there's going to be new buildings that are going to be visible from a public right-of-way. It's going to be a noticeable difference. And in my experience, the threshold for adversity is typically pretty low.
And then the reason that you don't think it reaches the level of an undue adverse effect is that influenced by a belief that it is somehow consistent with the character of the area.
It's only influenced in the sense that the second part of the Queechy test asks about community standards, whether or not reasonable mitigation has been implemented. And I don't think that the dissimilarity or similarity to the actual character is necessarily enough to cause an undue adverse impact, but I do think that it could cause an adverse impact.
And where's that line between adverse impact and an undue adverse impact?
That's a good question. It's something that isn't very easy for, I think, commissions, for 248 commissions, for environmental courts to be able to answer. It's very fuzzy. And so you have to go through the questions under the second prong of the Queechy test to see if there's some sort of hint. Usually where it ends up is whether a project is shocking or offensive. And as I set forth in the testimony, I don't believe that this site is shocking or offensive.
But that second part of the Queechy analysis, you find the way the analysis works is you're meant to find an undue adverse effect if the project triggers any of those second prong factors, right?
That is my understanding, yes.
And what are those second prong factors?
So does the project, I mean, all of this is in the testimony, so if you're just asking me to recite it,
well,
I'm wondering if you're wasting everyone's time, but
I assure you I'm not wasting everyone's time. I have clients who, they may read your testimony, but it's very hard to understand the Queechy test, as you might know, to people, especially if they're lay people. And I think that it helps, you just focus, for example, on one trigger of the second prong. In the context of that statement, I mean, it's helpful to understand and be fresh in our minds, what are those other prongs?
So the first question is does the project violate any clear written community standards? The second, and
so let's just stop there. Did you review any clear written community standards in your Queechy?
I reviewed the standards.
What were they?
I reviewed the town plan. I reviewed a very old open space plan. I reviewed the regional plan.
And aren't there policy preferences stated in those documents for not increasing development in Lakeshore?
Objection, relevance, policy preferences, as we all know, are not mandatory regulatory standards in town plans and are not binding in an Act 250 proceeding.
I'm not suggesting they're binding, I'm suggesting they would influence the analysis.
Mr. Owens, you can answer the question.
Can you ask it again?
Would you agree with me that there are many statements in those documents that you just talked about referring to relative to community standards that indicate that there's a preference for not further developing the Lakeshore?
So I don't know that that question is relevant to what question is asked under Queechy, which is, are there any specific standards that relate to scenic protection? It's not about development. It's about protecting a specific scenic quality or location.
Right, so can we agree that the project does not protect the scenic quality of the trees that currently are the predominant visual aspect of the site?
That's not the question that's asked. The question that's asked is, does the project violate a specific standard with respect to scenic protection?
And the specific standards you reviewed include statements to the effect that it's not desirable to continue developing glaciers.
Objection. If he could direct him to specific language, to ask him to have in mind all of the language of the town plan and be able to respond to that question is unfair.
I'll withdraw the question. Could we find exhibit or document number 085? I'll get out. So please zoom in on that a little bit. A little bit more, yeah, please. So earlier, when you were testifying, and I was asking about the trees that would be removed, it would basically be the bulk of the trees in the center mass of the project site, correct? That we're looking at in document 085.
When you say the bulk, I would say yes, with the understanding that not all of the vegetation in that center of mass that you're referring to.
Right, there's gonna be 5 or 6 trees or somewhere around that number of trees that are gonna be left in the middle section, and then there's gonna be a number of trees left on either side.
Right.
That's what we talked about. And we've seen the elevations of the project site, but those trees, instead of seeing that view that we're looking at now, if the project's built, you'll see the profile of 7 buildings, right?
You would see 6 or 7, yes.
And those are buildings with glass and concrete and steel, right?
I would say that most of the materials that you would see would be glass, and then the treatments on the exterior of the building, which includes stone. I don't know that concrete is one of those treatments.
Okay.
I believe that it's stone.
And when you talk about an adverse effect under the Queechy test, the adverse effect is it fair to say that it's going from this, what's in 085, to the built site? Is that what the adverse effect is? Is that transition or that change?
Yes, it would be the noticeable change from what currently exists to installed new buildings.
All right. And whether that adverse effect is undue or not, as we're talking about, depends on whether you hit these triggers under the second prong of the test, right?
That's right, although it's not whether or not I think so, it's whether or not the commission thinks so.
Sure, but your opinion is based on whether you think so.
That's correct.
And we just talked about a little bit about the trigger of the written community standard. What's the second trigger?
I'm sorry?
What's the second trigger?
So it could be one of, does the project offend the sensibilities of the average person? Or did the project employ reasonable mitigation?
Right. And, theoretically, there could be more mitigation than what's proposed, correct?
Yeah, theoretically, it's pretty open-ended to, what could be done. You could modify to your wit's end.
Right. The project could have been designed to have a lot more vegetation between the buildings and the lake, right?
Potentially, yes.
And that would reduce the visual impact from the lake, correct?
Possibly.
Can we go to 050? So we're just going to look at the difference between what we have here is 085, and then we're going to look at
You said,
050. So now we have up the elevation drawings of the proposal. Is that right?
Yes, that's the conceptual perspectives that were prepared by the architect.
So that's what we can expect the project to look like from the lake once it's built.
Not necessarily, no. This is more of an illustration and intentionally reduces the visibility of the vegetation so that you can see the architectural aspects of the project without interference of the landscaping, although the proposed landscaping is approximated
Yeah, I think there's a version here of the landscape. There we are. So most of that screening is not anticipated to screen anything above the lowest floor, correct?
So this again is an illustration. It's not intended to be an exact replica of what you would get. I don't know, the growth rates that would have been equivalent for each of these individual trees, although I think it's reasonably approximate for what you would see in a conceptual perspective such as this.
So this visual impact of what we're seeing here, though, is very different from what we were looking at a moment ago in 085 with all a treed shoreline, correct?
When you say visual impact, are you suggesting that the two perspectives have separate visual impacts of their own?
What I'm asking you is that, I think you answered it relative to the adverse effect, so I'll move on. Did you, in your analysis, consider the requirements of the Shoreline Protection Act at all?
The Cucci analysis does not, as far as I understand, consider shoreline protection whatsoever. It's looking at whether or not there's community standards with respect to scenic protection.
And then, so you didn't make any distinction in your analysis between what was in 100 feet of the shoreline versus a 250 foot of the shoreline?
Under Cucci, no.
But in general, you didn't make that distinction. That's not a distinction that's important for your testimony.
When you say in general, can you be more specific?
Just in your analysis, you didn't look at what's in 100 feet versus 250 feet as having any particular importance.
In the Cucci analysis, no.
And did you review the prior permits for the site?
Can you be more specific about prior permits?
So this is like a -8 project, right? So meaning that there's been 7 other permits issued by Act 250 for this project?
Okay,
for this site?
Yeah, the answer is no. I did not look at prior permits.
So are you aware that there were trees on the south side of the project site, or the south side of West Lakeshore Drive, that in prior applications, the permits that came out required keeping those trees?
No, I'm not aware of that.
So if prior applications or prior permits contemplated keeping trees that are going to be removed for the parking or the roadway on the south side, how should the commission consider that?
I mean, that's not really a question for me. That would be a question for them. But my expectation is that you would potentially look at what the purpose of those was and whether or not some sort of reasonable replacement maybe should be made, or whether or not they're no longer appropriate.
You haven't analyzed what trees are supposed to remain on the project site based on prior permits and done any sort of assessment of how to carry forward any of those protections?
No.
The proposed slope restoration follows major grading and reconstruction of the existing slope, correct?
Major regrading, yes. Although I would just say it's probably just regrading.
Well, do we know what the current slope is of the project site?
Do you mean like how steep it is?
Yeah.
Well, it varies throughout. In some cases, it looks like it's more than a 2-to-1 slope, which is pretty steep. Steep enough to be difficult to access, and in other locations, it's a little bit less steep.
It's steep enough that it's basically the slope is being removed to accommodate the buildings, correct?
Objection. No basis in the record for removal of the slope. It's not going to be a flat site when it's done.
Well, I'll put it this way. Instead of a steep slope, there's going to be vertical walls in certain places, right?
Are you talking about the sides of the buildings?
Yeah.
Yeah, I would say that you'll see walls where there used to be steep slope.
Okay. And is it this way, is there a reason that caution is required when building on steep slopes?
From an aesthetic standpoint?
Yeah.
I'm sorry.
Yeah, is there anything special about slopes like the project site as it currently exists from an aesthetic standpoint?
I mean, in terms of mitigation plantings, you would not want to plant on very steep slopes. So otherwise, I don't really understand the question.
Right. During construction, the proposal relies on biodegradable matting and an annual cover crop for short stabilization, is that right?
So the annual cover crop is for short term, yes, and the biodegradable matting would be for immediate erosion control prevention.
And so as with the visual mitigation, the permanent stabilization benefits of the proposed plantings develop after establishment, not immediately after installation, correct?
That's correct.
And you did not design the stormwater system, correct?
Correct.
In your opinion, that the plantings complement stormwater treatment assumes the civil stormwater design performs as it's intended, correct?
No, it only assumes that the plantings themselves will be able to uptake water.
Did you do any soil testing at the project site?
No.
Did you review any of the historic soil testing that was done for prior permits?
No.
The project includes lighting for access drives. Do the plantings that you have proposed for the project site, are they flood resistant plantings?
As far as I understand, the flood level of Lake Champlain is 102 feet, which is well below virtually all of the proposed plantings that we have for this site.
Are they high water table resistant plantings?
I don't know enough to answer that question right now.
The project includes lighting for access drives, sidewalk, parking, pedestrian stairway, building entrances, outdoor seating, and a bike storage area, correct?
Can we go through that list again?
So the lighting in the project includes lighting for the access drives, the sidewalks, parking, a pedestrian stairway, building entrances, outdoor seating, and a bike storage area, right?
Portions thereof, yes.
Right. And the crossing includes 4 additional fixtures at 4,000 K.
That's right.
And the crosswalk is also under an existing town streetlight.
That's right.
You did not, or tell me if you did, but you did not conduct a post-construction field measurement of glare or spill, because it can't be done yet, right?
I'm confused about the question of glare. Are you talking about light spill?
Light spill, yeah.
No, we can look at pre-construction estimates, but not post-construction, obviously.
And your conclusion regarding neighboring impacts rests on proposed photometric plan and fixture specifications, correct?
Can you state that question again?
Your conclusion regarding the impacts on neighbors of the lighting for the project is based on the proposed photometric plan and fixture specifications, correct?
That's correct.
And the parking area occupancy sensors do not eliminate lighting at all other proposed project fixtures, correct?
That's correct.
And then you heard the discussion earlier about the south side of the parking area, the existing site.
South of the Hazelett facility.
So there's no additional lighting proposed for people who would be parking in the southern side of the property and walking up to the project site, correct?
That's correct. None is proposed, although I would assume that if that was needed, that would be looked at.
And then if it were needed, one of the things that would have to be looked at would be the visual impact on neighbors, correct?
Well, it would, in order to meet local standards, they don't want the lights to spread onto neighboring properties, so therefore to pass local permitting, that would be needed.
So it sounds like there's, well, is it fair to say that additional lighting may be needed for pedestrian safety?
I think it's fair to say that depending on existing conditions, additional lighting may be needed,
Thank
but
you.
I haven't looked at it.
All right, thank you. Nothing further.
Thank you. We're going to take a 7-minute break right now.
Thank you.
Yeah, we are recording again.
Yeah, so our apologies.
He gets some, all right. Okay, let's go on with Mr. Homestead.
Are we able to ask a few
I
redirect?
thought we were gonna do that toward the end, but we can do it, you want to do some redirect now?
Yeah, it's just,
Okay.
just when the witness is here and it's very short.
Chris, before you start that, can I just ask one thing, just as a question about how the commission's considering the town plan? I just want to make sure, with that last witness, I would have made the town plan an exhibit.
I think the town plan is in the record.
It is in the record.
I mean, typically, my view, I mean, everyone's got a different view on these things. I view criterion 10 as the commission's decision. Here's the project, here's the plan, and there isn't a lot more evidence that's relevant to that. The project's the projects, the plan's the plan. People can offer commentary on it, but I think at the end of the day, those are the two things that end up mattering.
We've had a lot of experience reading town plans.
Oh, I'm sure. I just want to make sure it's in the record, and we don't need to make it an
No,
exhibit.
we can take judicial notice of it
Thank
as well. And Mr. Roy,
Yes, very briefly. Does the town have guidelines regarding the removal and replacement of trees?
Yes,
And does this project comply with that?
yes.
If you could put up Exhibit 115, please. Actually, how about Exhibit 85? Let's start with Exhibit 85. Sorry, apologies. If you could move all the way to the left on the photo. So if I could direct your attention to the far left of that photo, do we see a building with no screening between it and the lake?
Yes,
And then if we move to the right, the next building, do we see a building facing the lake with no screening between the, no, still over there. There's two over on the far.
there's three.
So we've got a second one there, it's right up near the lake and there's no screening between it and the lake, correct?
correct.
And the next one, there's open space with no screening along the lake, correct?
That's correct. I think that the building that you might see there is on the other side of the road.
Yeah. And then if we go all the way to the right side of the photo, we can see the Bay Harbor Marina structure with no screening between it and the lake, correct?
Correct.
Is it fair to say then that the subject parcel that we've been talking about with woods on it actually is the exception to what is typically seen along this stretch of shoreline?
It's definitely a little bit different than the adjacent properties, yes.
And we can't really see Bay Harbor real well on that exhibit, so if you could pull up Exhibit 115. This is a collection of three photos. You're familiar with these three photos of the Bay Harbor Marina?
Correct.
And this is the adjoining property to the west, correct?
Yes.
And for purposes of evaluating context and impact, for purposes of the Queechee analysis, would looking at the adjoining property be relevant?
Yes, for context of the surrounding area.
And is it fair to say that that project has a structure right up near the water with a large expanse of parking and no screening between all of that and the water?
Correct.
If you could move to the second photo on that exhibit. And does this, is that consistent with your statement that the structure and other development is up near the water with no screening?
That's correct.
And to the right of that, do we see a house, a White House two-story structure with a slanted roof with no significant screening between it and the camera.
Yes, I believe that house is on the south side of West Lakeshore Drive.
And then if you could go down to the third photo. Again, does this show a view from the lake looking toward West Lakeshore Drive in the vicinity of the Bay Harbor Marina parcel that shows docking, boats, structures, and other development with no screening whatsoever?
Correct.
I have nothing further.
Can I follow up on those questions?
Yes,
Just
stay focused, everybody.
So just following up on Mr. Roy's questions, notwithstanding the absence of some of the visual screening that you and he have just discussed, would you agree with me that the town plan, and I can put up, I can share the screen if it's still possible. What's that?
I'm happy to share it if you want to. I think you're still looking at it.
Yeah, if I could, I have to rejoin the Teams meeting for some reason. Okay. You can let me back in. Thanks. And you recall earlier, we were talking a little bit about written community standards as well. Do you recall that discussion?
Yes.
So the town plan is a written community standard, correct?
The town plan is a written document. I wouldn't say that everything in them is a community standard.
Don't we look to town plans to establish community standards?
I looked at town plans to establish whether or not there is an existing community standard with respect to scenic protection of the location or area.
Right. And do you agree with the paragraph or page 19 of the town plan says views and access to the bay should be preserved and enhanced?
I see that, yes.
Isn't that a written community standard that would be useful in the Queechee analysis?
Objection. It is abundantly clear and has been for years that the word should in that means that it's aspirational and not a provision that acts as a regulatory standard for purposes of criteria intent.
All right, I think the commission understands that, but I'd like the witness to answer the question.
So I would not consider that a clear written community standard that applies to the project. I would consider that something general. I would also say that my interpretation of that sentence is that it appears that they want vegetation cleared so that they can have views of the water, and also that they would like roads and potentially pedestrian access that takes you to the water.
Does the zoning implement the town plan?
I believe that the zoning and the town plan are compatible with one another, yes.
And the zoning also, is it fair to say the zoning also provides written community standards?
I am going to object because I was very careful to restrict my questions.
I'll withdraw. It's something we can address it on our memos. Although, is the zoning in the record?
I don't think that the zoning has been entered into the record at this point. I can double check that right now.
So we'd ask the commission to take judicial notice of the zoning bylaws.
Supplement 47. It's changed since the application came in.
It's applicable as when an application is
Right.
submitted.
Exactly. I can give it to you.
Okay. Thank you, Mr. Owens.
We're going to now.
Sorry, do we need to make an exhibit of the zoning? No. Take judicial notice of it. Thank you.
We are going to take the last two out of order, if we may, and do the architect, Jessica Gasek, next. And she has presented pre-filed testimony relating to criterion 8 and criterion 9F regarding energy efficiency. And we make her available for any questions.
we even have her, I'm sorry, I might have missed it. Did she verify her testimony?
Yes.
Oh, sorry, I missed it. Good morning. Your testimony describes 5 cottages and a central main building, isn't that right?
Yeah.
And cottages 1 through 4 are approximately 2,900 gross square feet each.
Yeah,
And cottage 5 is approximately 4,600 square feet.
yeah,
And the main building is approximately 9,500 square feet.
yeah,
And the main building is where the restaurant, multi-purpose event space, and fitness center are located.
yeah.
And, is there also a spa there?
There is a, small spa fitness center, yeah.
And all the cottages and the main building appear as 3-story structures from the lakeside, correct?
Correct.
And the buildings are placed into the slope so they have an additional walkout level towards the lake, correct?
Yes, so they're 3 stories from the lakeside, 2 stories from the street side.
With entrances and exits both on the lakeside and on the street side.
Yes.
So the project has therefore multiple 3-level lake-facing structures on the slope, as we've seen in the elevation drawings, correct?
Yes.
And just to make sure I understood the drawings correctly, the main building where the kitchen is has an area that is going to extend back into the slope and will be under the sidewalk, is that right? Is there any, in a scenario like that, where you have the potential for vehicles being on the ground above portion of the structure, are there any additional structural measures you put in place to address that?
It hasn't been designed yet, but yes. There would need to be a structural analysis of that roof structure to maintain proper loading for vehicles and pedestrians.
Ms. Kasich, could you use your
Outside
outdoor voice?
Yes, sorry.
And so when the citizens looked at that, one concern was just that issue of the structural ability of that area to withstand any sort of like car going off the road or something like that. So you're saying that, or even just the cars on the driveway. So you're saying that what needs to be done to accommodate that structurally has not yet been determined.
Correct. Yeah, we don't have a structural engineer on the team yet at this stage of the design.
Thank you. You're not offering an NFPA or fire code maximum occupant load calculation in your testimony, are you?
No.
And you did not identify the square footage of maximum occupant load for each restaurant, bar, event, deck, or accessory area in your testimony, did you?
No.
And you did not identify a maximum occupant load for all spaces used simultaneously, did you?
In my testimony, no.
And the plans include multi-purpose event spaces, correct?
Yeah.
And event spaces are designated for flexible use?
Yeah.
The main building also contains outdoor decks, correct?
Correct.
And your testimony does not identify a binding limitation on the use of the decks for dining, reception, or other gatherings, correct?
Correct.
Your testimony does not state whether any operable partitions may be opened to combine event spaces, correct?
My testimony, no. The drawings may indicate, operable glazing. I'd have to look back.
And you've not prepared a traffic, parking, or wastewater analysis based on maximum building occupancy, have you?
No.
Regarding accessibility, you're not providing an Americans with Disabilities Act compliance opinion in your testimony, are you?
Not in my testimony, but the design would comply as is required by the building code.
Including the cottage 5?
Refreshing myself, cottage 5. Yes, that would have to be analyzed and comply.
So there might be changes needed to ensure ADA access?
I don't believe so, but we haven't, there might be
further analysis to confirm, but I think as designed, the intent is that we meet the ADA requirements.
What's it? Yeah, is there an elevator in cottage 5?
No, but not all rooms have to be accessible based on the ADA standards. It's a certain percentage of the overall number of rooms.
Okay. And would the bathhouse be ADA accessible? Or
Yes.
intended to be?
Yep, the intent is that that is accessed from below and via the accessible sidewalks along the lakefront. So anybody using the beachfront can access the building.
And you're not providing a fire apparatus access opinion, are you?
No.
In looking at the plans, one of the questions that came up was, it looks like did you analyze whether the fire lane is sufficient for fire trucks to be able to?
We had conversations with the fire department on that fire lane width,
What's the width of the fire lane?
20 feet.
And is that, can we put the site plan back up? Is that 20 feet, including or not including portions of the travel roadway?
Including, but I would defer those specific questions to the civil engineer.
Okay. What would the emergency access be for the lakeside of the buildings?
Again, I would defer to the civil engineer or Ben, who had direct conversations with the fire department. But they were, we did have conversations with them about what access they need and what accommodations they require.
Just looking at the site plan, one of the other questions that's come up that maybe you can help us with, or maybe you refer us to someone else, is it look like there's a dumpster in the northwestern section of the property, and then there's a gate and snow storage in the area that accesses that. Is that dumpster going to be inaccessible during the winter?
I believe that is a seasonal dumpster for the marina space, but I would ask that you confirm that with others.
Thank you. Oh, yeah. And then on the driveway where we're inquiring about fire lane and fire safety, are you, just help me understand, are you saying that the width of the entire driveway, including the fire lane, is 20 feet?
That I would ask the civil engineer.
Okay.
Can she test these?
Should I just ask the civil engineer? You're not providing a commercial kitchen operation or waste handling opinion, correct?
Correct.
And your testimony does not identify, well, we already talked about the building, but your testimony does not identify a service elevator for movement of carts, linen, supplies, dishes, and waste through the main building, does it?
The main building shows a personnel elevator and a service lift, I believe.
Yeah, is that like a dumbwaiter though? Not a...
It's for just catering carts. That's intended to be that size for.
Not intended to carry people though?
No.
And your testimony does not identify the year-round route for waste from the upper level event areas to the dumpsters. And it sounds like one of them might be, well, that's correct, your testimony does not address that.
I don't address that, no.
And the only other dumpster, other than the one that we just said might be seasonal, is across the street, isn't it?
I would defer to civil on that, please.
Okay. And your testimony does not identify the final location and capacity of an on-site laundry facility, does it?
Correct.
Your testimony states the design has not progressed to the level of detail necessary to identify final energy measures, correct?
Correct.
You also say, when would that be done? When would you determine final energy efficiency measures?
So we would need to bring on mechanical, electrical, plumbing engineers, and that doesn't typically happen until design development when we're through these sort of permitting exercises.
You also say in your testimony the mechanical and electrical systems have not yet been designed, correct?
Correct.
You cannot identify today the final HVAC system, client schedule, or final thermal envelope specifications for the project, correct? And you would not be able to identify today whether the design will exceed rather than merely meet the applicable commercial building energy standards?
I can't guarantee it would exceed, no, but in our office, we tend to exceed the energy code just as practice. It's fairly easy to do, but we would meet the energy code as a minimum.
So the applicant's conclusions regarding criterion 9F depend on future design and code compliance matters, correct?
Code compliance would satisfy the criterion.
Thank you. Nice one. Oh yeah, so are you able to tell us what the relative, like what the elevation or actual height of the buildings are?
I believe on the drawings, I have heights called out. Yeah, we dimensioned building heights for zoning compliance, which is taken based on average grade around the building. And then I have sort of an actual perceived height at grade from the street side listed.
And what's the exhibit you're referring to?
I have the architectural drawings. I don't know what the exhibit number is on those. You know?
Okay, if you put it up, that'd be helpful. While we're waiting for that, can you just tell me, was the manager's unit designed for residential purposes?
It was designed as a variant of one of the rental rooms. It's included in that count. Is it a kitchen?
It does have a kitchen though, correct?
Yes. Yeah, and I think Colchester's zoning requirement for an inn stipulates only a certain number can have full kitchens, and we're within that number for the.
Well, since you mentioned it, doesn't that also include other types of living space common to apartments other than kitchens?
Yes, I don't remember the exact language. Kitchen, bath, living space, and separate bedroom, I believe is how they define.
Right, so there are living spaces and
separate bedrooms, so if they have full kitchens and separate bedrooms, more apartment style.
right, but the zoning, just because you brought it up, the zoning definition doesn't say it has like all those things. It says it has any of those things, correct?
I don't believe that's how it's intended, but I don't have the exact verbiage in front of me.
All right, and then does cottage 5 have a separate laundry area, or laundry facilities?
No.
No separate laundry facility in cottage 5?
No.
Does it have a pool?
Yes.
Does it have a kitchen?
Yes.
We weren't able to get those up?
Teams right now is deciding that I'm not able to share my screen.
Probably
so,
because I'm sharing, do I need to stop?
Oh, are you sharing still? Yes,
Oh,
that's
I got out. I could leave, that might help.
No.
Sure.
We'll call it a day.
Set yourself up for that.
That's fine. I get that a lot.
No one's a part of it. No.
So, I'm gonna move on, or well, without that, I don't have any other questions.
If we can, we just need 1 second, we can definitely get it up there. It's just being a bit cranky right now.
And exhibit 50 you're trying to pull up?
I don't know if it's just in here, if it's.
If this relates to 9F, I know it's in the pre-file testimony, but it's my recollection that no one is an interested party on 9F. And it wasn't listed as our contested criteria. So I don't.
All right. That's fair. Just in regards to the square footage, is there somewhere I can find square footage calculations for all the units?
I don't believe that's included in the drawing package as it was submitted. The testimony has approximations of square footages.
All right, so to be clear though, the application materials do not identify the square footage of all the units.
I do not believe so.
All right, thank you.
I just want to, it seems like Jen wasn't even able to join Teams, so I just
tried to rejoin too.
and it wouldn't let you. Okay, that's it.
It's opinionated.
Yeah, well, just as problematic if anyone is trying to join remotely.
What do you suggest?
I think it's not something, it might be a network thing. I think we continue, and if anyone is notified that someone's trying to join and they've texted you, and we can try to get them on the phone or anything like that, I guess is what we can do in this moment.
Yeah. We're still there. Okay.
We have no redirect questions for this particular witness.
And I think, thank you, Ms. Gasek. We can move to Exhibit 113 and Mr. Homestead.
And so, as you mentioned, Mr. Chair, Exhibit 113 is Mr. Homestead's pre-filed testimony, and we make him available to testify with respect to criteria 1, 1B, 1C, 1D, 1F, 1G, 4, 7, 9A, 9H, 9J, 9K, 9L, and 10, and he's also available to the extent, and I would like to raise questions with respect to 1E.
Would A&R or V-Trans like to ask any questions?
Jen Mojo, Agency of Natural Resources, no additional questions.
First file, V-Trans, no additional questions.
Okay. Mr. Simon, you may proceed.
Thank you, Mr. Chairman. Good morning.
How's it going?
Good. You were retained by the applicant as a civil engineer of record, correct?
That's correct.
You performed a site visit on May 13th, 2026.
That's correct.
Your site visit was not, it did not involve, and you have not done any subsurface soil investigation, correct?
Not on this portion of the property, no.
And by this portion, you mean the north of West Lakeshore Drive and the south of
The areas of the proposed development.
Right. And you have not performed infiltration testing on the 166 and 180 West Lakeshore Drive parcels?
No.
Correct? And you have not personally excavated any new test pits on those parcels?
Correct.
And your conclusion that infiltration-based systems are unsuitable rests in part on the asserted seasonal high water table condition, is that right?
It's based on the Soil Conservation Service hydrologic soil group mapping.
Right, so it's based on general mapping, not specific site-specific testing. There has been site-specific testing on the property owned by Hazelett, though, correct?
In other areas that I'm aware of.
Including back in the area where the retention pond is being converted to gravel wetland too?
I'm unaware of that, but if there's some historical, we did extensive research on the files for previous stormwater and wastewater applications for the site, and I don't recall seeing any test pit data in the area of the gravel wetlands.
Wasn't there a permit allowing for septic infrastructure in that vicinity?
The only, the permit for, unbuilt septic infrastructure, if that's what you're referring to, is for a wastewater system back in the woods, 1,500 feet away from the site and very uphill, so it's completely irrelevant.
Right. So, and you did not review any of that?
No, that was our project. We did that wastewater design, I think, in 2017.
And Scott, you'll want to let him finish the question before you answer.
Thank you.
Okay.
So when your firm has done testing on Oh, okay, strike that. Is the classification of the soils there, or maybe tell us, what is the classification?